Nadir Syed, Secretary of State for Justice.
Well, I represent Mr. Syed in these proceedings. My learned friends, Sir James Eadie QC and Mr. Charlotte QC, represent the Secretary of State. My Lords, you see, you have two appeals before you today. Both parties appealed on the by way of notice of appeals on the 27th of April 2017 against Mr. Justice Lewis's order. And permission to appeal was granted in both cases by Lord Justice Lewis on the 11th of January 2018. Lords, you should have before you a consolidated core bundle of 22 tabs. And in that you should see in tab 4 you have skeleton arguments from both parties as appellants. And tab 20, both parties as respondents in the core bundle. And you should have a supplementary bundle of 148 pages. And an authorities volume should have 28 tabs, and a couple of tabs spare at the back. My Lords, in terms of the order of submissions, we're very much in the court's hands, given that we're both, let's say, appellants and respondents. I mean, it was intended that I would open our appeal, but whether the court would then wish me to deal with Article 8 before hearing from the Secretary of State, or for the Secretary of State to make his submissions, then for me to respond.
Good. Well, I think we had a very brief discussion about that. If you haven't already made up your own minds and reached an agreement on it, I think our preference would be to hear your appeal first, with a response on that, so that we hear the whole of that issue first, and then the Secretary of State to open with the Article 8 point, if that's convenient.
Well, yes, I can say I'm going to be pretty short on the Article 8 point, for reasons that will be immediately apparent to the court. I suspect that the issues of principle have shrunk down to almost nothing, and there is a residual question as to where the facts lie on either side of that line.
Yes, very well. But if that's convenient for counsel, that's the way we'd like to approach it.
Certainly, yes. Both appeals concern Mr. Syed's transfer to and holding him in the Managing Challenging Behaviour Strategy Unit, or the MCBS unit, where he was transferred on the 2nd of November 2016. And as
please remember that we have read all the skirmish documents and read the judgment.
Yes, all right.
So
yes.
You don't have to go into the facts too carefully, but obviously as so much as you need to.
Yes, and that was intended to give because the facts are largely agreed, but I'll give an overview of the relevant factual material. The issue in our appeal is whether Mr. Justice Lewis was right to hold that transferring Mr. Syed and detaining him in the unit did not constitute a removal from association within the meaning of Rules 45 and Rule 46. And in particular, we say did this constitute removal from association? The meaning of removal from association is the same under Rule 45 and Rule 46, but it's in particular Rule 46 that is very close to the type of what we say removal from association that occurred in the present case. And that's Rule 46 covers removal to what's called a close supervision centre in a prison. And in fact, Mr. Syed in this case was referred to a CSC that was found not to meet the criteria for being transferred there, and he was transferred instead to the MCBS unit. And as we'll see, had he been sent to the CSC, he would have been held in virtually the same conditions and for virtually the same purpose as if he'd been transferred, or as he was when transferred to the MCBS unit. And the question is that in effect a Padfield breach? Is transferring him there outside of the statutory scheme, or transferring him to such conditions and for such purposes outside of the statutory scheme, to thwart and run counter to the purpose of the prison rules, structured as they are? In terms of the factual background, I will be brief, and I'll deal with a number of matters. Firstly, the aims of the MCBS unit. And they are intended to house prisoners were considered too dangerous or disruptive for an ordinary wing, and they were considered to require management in a small unit from which they're kept separate from the rest of the prison population. And the nature of that regime is helpfully summarised, we say, in an inspection report, which it may be helpful just to turn it up. It's at tab 18 of the authorities bundle. And this is an inspection report of both the MCBS unit and the CSC. But as we'll see, they're treated as very closely aligned by the inspector. And the first paragraph summarises the purpose and nature of. This is the authority, should be the red authorities bundle.
Oh, I see, leading material. I'm so sorry. Yes. Yes.
But if bundles have that, that's we say a helpful summary of the nature of the regime and its purposes.
Would you accept the CSC and the MCBS are two separate systems?
Well, yes, but that's key to our case. They are separate. The CSC is subject to a quite different regime to statutory authority. The MCBS unit isn't. It's a description of the purposes, which are very closely connected, and also the description of the regime, which you'll see it's the CSC holds prisoners for many years in the most restrictive conditions in the prison system with limited stimuli and human contact. MCBS unit's similar but slightly less restrictive, and they're both described in a somewhat colourful phrase of extreme custody. And the conditions, and we say that is a fair description of the conditions in the MCBS unit. Prisoners can be held in the unit potentially for years with no or virtually no contact with any prisoner outside the unit. Mr. Syed was eventually removed from the unit. He was gradually moved off the unit in February 2018 and completely off the unit in March 2018. So he was there for roughly a year and a half, which seems to be the average stay in the MCBS.
Where do I find on this page the reference to extreme custody?
It's the end of the first paragraph, last sentence. This is extreme custody, and its management raises complex operational challenges and profound ethical issues.
This is on page 9.
Page 5, my lord. Sorry. I apologise, my lord. It was the first paragraph on page 5.
I see, yes, thank you. Yes, thank you.
Well, in terms of the conditions within the MCBS unit, again, just in summary, at the time of the hearing for Mr. Justice Lewis, there were 7 prisoners in the MCBS unit, and they were split into different groups, 2 groups, 3 groups, and sometimes 4 groups. And prisoners were allowed out of their cells to associate with one another, but only within their group, during what was called association time. The association time was split between the different groups, so the more groups there were within the unit, the less association time there was. On his arrival in the unit, Mr. Syed was held for the first 5 or 6 days without being able to associate with any of the other prisoners within the unit, and thereafter the amount of time he had for association varied, but essentially it was between 1 hour 30 a day and 2 hours 15, depending on how many groups there were at the time within the unit. And during that time, during that association time, there were no educational classes or any other activities. All prisoners were able to do was, during that time, that's when they showered, exercised, used the phone, or they were able, I think there were some board games within the unit they were able to play with the other prisoners or with the prison officers.
What was the rationale between the groupings, the 2, the 3, the 4? Was there an Islamic aspect to it?
There wasn't evidence of that. I think it was just safety, whether the prisoners were regarded as able to interact with other prisoners. It wasn't said that that was the reason for it, I think, at the time in question. And for the first 3 months, that's until the 2nd of February 2017, Mr. Syed wasn't able to leave the unit at all. After that, he was able to go to the library for 45 minutes a week, but when there were no prisoners from the mainstream prison population present. And a couple of days before the hearing, so the 17th of March, he was able to attend weekly Friday prayers in the with the main prison population. We say that regime is fairly described by the Chief Inspector as involving limited stimuli and human contact, and as close to the most restrictive conditions within the prison system. And it's no part of our case that that may not be justified as a general matter, and it's not our case on appeal. We're not challenging necessity in relation to this particular appellant. What we do say is that a regime of that nature requires statutory authority, and that it also engages Article 8, the 2 issues on appeal. Indeed, it's close to the definition, the international definition of solitary confinement. You see, we refer to that in our skeleton at paragraph 12. Which defines solitary confinement as prisoners being locked alone in their cells for 22 to 24 hours a day, with meaningful contact and stimuli reduced to a minimum. In this case, Mr. Syed was just off that. He was locked in his cell for roughly 21 to 22 hours a day.
Who lays down that description? What's it for?
It appears in a General Assembly resolution called the Mandela Rules. Is where we've taken that from. And we say, we don't say his conditions...
But is that and is it there because there's some UN statement about when it is appropriate and when it isn't appropriate?
The statement there, yes, it's a statement there about, or there it's about the duration in which solitary confinement is regarded as appropriate. It's set out in the Mandela Rules. The reason that would be important is not because we say we're relying on those rules, but when we look at the domestic authorities, particularly Shahid and Bourgas and Hussein, they talk about the dangers and the damage that can be done by solitary confinement. And we say this is close to that definition.
Mandela rules, just note, those are tab 21.
Yes, well, it's Rule 44.
Page 33, yeah.
It's Rule 44 sets it out. Well, yes. It does.
Thank you.
And then what we do say is that is those conditions in detention, again, this reflects the Chief Inspector's report, are very close to the conditions that are applied to prisoners within the CSC system. And my lords, we see that again if we go back to the inspection report at tab 18. If my lords turn to page 10, you'll see it sets out the various different units, the various different CSC and MCBS units. And we'll also see that the CSC, again, the units are all, the unit size there, it's all between, I think, other than one that's slightly smaller in an assessment unit in Wakefield, they're 8 to 10, maximum capacity 8 to 10 prisoners and similar normal operating level in the unit. And we'll also see Woodhill A and B wings are MCBS, are CSC units. Well, Mr. Syed was in Woodhill Central MCBS Unit C wing, so you have the two CSC wings, and then the next wing of, you have A, B wing, and then C wing, essentially in the same unit, is the MCBS. So unit was probably the wrong word. Essentially, the three are next to each other. You have three units.
A, B and C.
A, B and C. Two CSCs, A and B, and then C wing is the MCBS unit. And again, you'll see similar capacity, similar size. And also, in terms of the regime in the CSC unit, you'll see they're set out at page 36.
Most of these MCBS only seem to have one prisoner.
Yes, it appears that they're within segregation units. So that's, again, we'll come back to that. That's within Rule 45 segregation units. It appears they will have a space for an MCBS prisoner. That's how we understand that. They're all within segregation units.
Because it's an iterative process that, having been segregated the first few days, they then can be given more associations. Is that the reason?
My Lord, no. In fact, we would say that's an important point. They're not. The prisoners allowed to associate within segregation units remain subject to Rule 45. So they remain, in principle, segregated. That indeed is one of our points about how one interprets removal from association. So we don't know exactly how it operates. It appears to be that within the segregation unit, a cell is designated for MCBS prisoners, but I don't know how it works.
Well, I mean, I think the point was made. I don't think there's any value whatsoever in the analysis. Is that in this chart here, where something's designated as a segregation unit, there's only one person held within it. That's all. There's
Yes.
no association with anybody else there.
Yes, well, I don't know how that would work. But it was page 36. Describes various of the CSC, the conditions in various of the CSC units. And it's paragraph 2.7 to 2.11.
So what do we get from page 36?
But just the conditions within the CSE system are virtually identical to the ones to which Mr. Syed was subject in the MCBS unit. In fact, his appears to be similar to the most restrictive of the CSC provisions. You see Wakefield. 2 to 3 hours out of their cell, as opposed to, for example, full Sutton unlocked together for 7 hours a day. And again, it's similar, 2.8, again, that's the same as for the MCBS units, an hour open exercise, and also the limited activities within the regime. Again, this is appears to be almost exactly the same as the MCBS unit. And also, potentially because the CSC is subject to statutory authority and a series of statutory protections, the guidance that accompanies it sets out far more detail in terms of the criteria for admission to the unit, and far more detail by way of process as to how one gets into the unit. And my Lords have at tab 23 the CSC referral manual. And page 4 identifying the right individuals. Again, I don't need to go through it in detail, but you see quite a bit of detail as to who ends up and why they end up in a CSC. May be referred one of the following: escalating violence, etc. And again, just a glance over, page 7 onwards sets out the CSC referral process, which is a detailed process involving, at various stages, reports being disclosed to prisoners, prisoners being able to make representations, prisoners being admitted initially to the CSC for an assessment stage, etc. The MCBS policy document you have at tab 27. And it's notable, we say, that there is far, far less, if at all, by way of procedural protection, detailed criteria. All we have on the process of referral to the MCBS units at page 15. The criteria you'll see at the top of the page. And the entire process is notification of cases.
So what is here that is not contained, which is contained in the CSC manual, that's relevant?
Detailed process by which prisoners are admitted to the unit.
And when you say detailed process, do you mean their selection, or do you mean other things apart from how they're selected?
The process by which, I mean, there's a series of, there's requirements to disclose reports, there's rights to make representations.
So what are the criteria for the CSC?
They're page 4, tab 23. identifying the right individual referral criteria.
Can you identify for us with particularity what you say is in tab 23, which is important and not in tab 27?
It's simply a far more detailed process, far more detailed as to who it's appropriate to place in the unit, and then when one looks at the process, and the only point we make from that is we say our submission that reflects the fact one is a statutory regime and the other isn't, and so this is what the consequences are for a prisoner of going through one route versus another. We say, in fact, you end up held in very similar conditions, but it's a quite different process with far more protections.
What is the... So far as these manuals are concerned, why does it make a difference if it's statute? Is that because in relation to CSCs, the statute requires a written policy or something?
No, my lord, no, it doesn't.
Because what you said before was you said because the CSC is statutory, the guidance for it is much more detailed. And just trying to understand, I understand it is more detailed, but why is it more detailed? Because it's statutory. It doesn't.
My lord's right. It doesn't have to be more detailed. We note that it is, and it's our submission that no doubt reflects the fact that one has a statutory basis. But I accept one could have a much more detailed set of criteria and set of procedures. Our submission is only as this is why it matters, which route one goes down. And our submission is that reflects the fact one is a stat provision, but I appreciate it doesn't necessarily follow that is the reason for it.
One thing you've identified is in the manual for the CSCs, it sets out what are the criteria for identifying who should go to these units, who are appropriate, whereas there's no such similar identification in tab 27. That's one.
Well, yes.
Now you also said that there's ability to make representations. Where do we find that, very briefly, in 23?
It's at page 8.
Yes.
Paragraph 3, this is the routine referral process. That provides for disclosure of reports. And then paragraph 6 is ability to make representations.
Is there anything else apart from those two?
Well, my lords, no.
No, that's fine.
It's the process and criteria.
Thank you.
My lords, my final point on the factual background is that, again, it's not disputed that the regime in the MCBS unit, or indeed the CSC, is obviously not normal association. As that phrase is understood, and we'll see that phrase appears repeatedly in the Secretary of State's documents, the normal association on a wing, of a prisoner on a mainstream wing, in terms of Woodhill, the prison where Mr. Syed was, it's set out in paragraph 27 of the judgment below. And it's that prisoners are out of their cell, able to interact with others for around 8.5 hours during the week, and 5 hours 45 at the weekends. And during that time, they interact both in what's formal association time or free time, but also during education, work, gym, etc. And they'll be able to associate with some 90 other prisoners on their wing. And for my Lord's notes, it's in the supplementary bundle at page 113. Okay, I'll turn it up. This is a witness statement from Mr. Syed's solicitor setting out the conditions in other high security prisons, so Long Lartin, Full Sutton and Frankland.
Which paragraph?
It's Long Lartin's paragraph 6. Full Sutton 7, Frankland 8. And essentially, in all of those prisons, during the week, it's 8-9 hours out of cell. Weekends, there it's 6 or 7 hours out of cell, and the wings hold something in the region between 40 and 90 prisoners. And it's not our case that there's some fixed or absolute number of prisoners that one has to be able to associate with to constitute normal association, or some fixed number of hours that constitute normal association. But we do say within the prison system, there is very clearly an idea of what normal association means. I say we'll see the phrase used to describe, or we'll see the phrase removal from normal association used repeatedly in the Secretary of State's documents. And that is because there is an idea of what that kind of association means. It's association during a range of activities, work, education, exercise. Certainly with tens of people, you see the number is 40 to 90, but it's with a significant number of other people for the majority of the waking day during the week. And we say that would be recognised by prisoners' staff as what normal association is within the prison system. Well, that's by way of factual background. Turning to Mr. Syed's appeal, his case rested on two propositions. Firstly, the prison authorities can only direct prisoners' removal from association for the maintenance of good order or discipline or to protect the safety of others if that is done pursuant to rules 45 and 46, or 46. Second proposition, Mr. Syed was subject to removal from association within the MCBS unit without statutory authority. And the first proposition, as I said, my lords, is essentially a Padfield point. It is that Rule 45 and 46 set out criteria for removal from association and a set of safeguards and authorisations. It would make no sense of having that kind of provision if there was also some extra statutory power to remove prisoners from association where the criteria weren't satisfied and without going through the same authorisation and review process. That would be, in Padfield terms, to thwart or run counter to the policy and objects of the prison rules of having these limited circumstances in which removal from association can occur and the conditions under which and the process by which it does occur. Well, that first proposition wasn't disputed below. It's not clear whether it's disputed now. One of the things that's said against us in the Secretary of State's skeleton is our case depends on there being a right to normal association.
So when you say it wasn't challenged, is what it is that you say wasn't challenged that it doesn't make sense to have some other means outside rules 45 and 46 for the removal from association. Is that the proposition?
Yes, the first proposition wasn't challenged below, that you can only direct prisoners' removal from association if it's done under Rule 45 and Rule 46.
Yes. And that's the way that, and that is because the Secretary of State's position is that removal from association means removal from all association. That's why they could agree that proposition.
It's the second proposition they dispute, which is that Mr. Syed was in fact removed from association. What they don't dispute is that if he was, as we understood it below, we understood it wasn't disputed that prison authorities can only direct removal from association if they're doing it through Rule 45 and Rule 46. What was disputed was the second proposition, was that Mr. Syed was in fact removed from association. The reason we say it's not clear whether it's still not being challenged is that one of the things that's said against us by the Secretary of State is that our case depends on there being a right to normal association. It's in paragraph 13 and 14 of their skeleton. And they say, if you look at Bourgas and Hussain, it is clear prisoners do not have a right to normal association. My Lord, what Bourgas and Hussain says is that prisoners do not have a right to any association. But our case doesn't depend on there being a right to normal association or indeed to any association. As I say, it's a Padfield point, which is that if you have provisions that say this is where you may remove from association for good order of discipline, you can't remove prisoners from association outside of that power. So we don't need a right to association in order to make that argument. That's why the dispute below and the substance dispute here is what is the meaning of removal from association? And the Secretary of State's case is that Mr. Syed wasn't removed from association because removal from association means denying all association with other prisoners, keeping prisoners entirely separate from the rest of the prison population, and that however limited the interactions are in terms of time, number of prisoners that a prisoner has, provided he has some association, some interaction with other prisoners, he's not removed from association. And our submission is that is not the correct interpretation, and it's removal from normal association. So turning into the statutory language, and we say that's right, we say it's a matter of statutory language, particularly if one reads Rules 45 and 6 in their entirety. We also say, insofar as there is authority on point, it supports that interpretation. It also reflects the way in which the respondent describes segregation and move to the CSE. It's described repeatedly. It's never described in the respondent's documents as removal of all associations, or it's described repeatedly as versions of removal from normal association, removal from denial of normal association with the mainstream prison population. And we say that's correct. And we also say it's right as a matter of principle, if I'm thinking about the policy reasons for having Rules 45 and 46. So turning first to the statutory language, and starting with the word association, Mr. Justice Lewis explained association, this is paragraph 41 of the judgment below, as where a prisoner may have contact and interact with other prisoners outside his cell, either generally or in particular contexts. And we say, just look at the word association, that is we respectfully say, a correct interpretation of it. The normal course of events, prisoners are able to interact with others outside of their cell in a variety of different ways, and that interaction, contact, is association. But we do say that interpretation of the word association supports our interpretation of the phrase removal from association, because it's referring, association is defined as only contact that happens outside a prison cell. Now, our case is that removal from association is taking prisoners away from ordinary contact, the normal association on the prison wing. The Secretary of State's case, it's about keeping prisoners apart entirely from the rest of the prison population because they're too dangerous or disruptive. But if that's right, it's not clear why a prisoner who's able to associate or able to interact and have contact with prisoners within their own cell is not regarded as, or is regarded as removed from association. That prisoner is not being kept apart from other prisoners. And in fact, the position of that prisoner is, we say, very similar to Mr. Syed. If you have a prisoner, if a prisoner who has a cellmate is nevertheless removed from association, why is that different to Mr. Syed if he's told, well, you can have an hour and a half interaction with another prisoner in a different room. If you have that interaction in your room, in your cell, you would be removed from association because you have that interaction with another prisoner in a different room. You're not removed from association. And we say that seems certainly rather odd that is a distinction. We say the fact that association is concerned with interactions outside the prison cell suggests it's not concerned with keeping prisoners apart, it's concerned with where association ordinarily happens and taking a prisoner away from that. Secondly, is the words removal from association. And it's the prisoner that's being removed from association. It's not something being taken away from the prisoner. And we say, again, that suggests association is something that happens in certain locations around the prison, and you're taking a prisoner away from that. That's what removal from association means. And we say if it was intended, removal from association was intended just to deal with keeping prisoners apart, it would have said so. And my lords, there are other provisions in the prison rules that are concerned with keeping prisoners apart. And my lords, I wonder if I can hand those up. I apologise, these are so last minute, but sorry, I've got. Sorry, I'm just. That's one set. These are two more. So they're all three. It's keep all three together, please. So. Sorry, my lords, you've got a broken up set. I wonder if you can combine those into one, and then you have two more. Apologies, I had.
Can I just ask you? I'm trying to understand. Your first submission on this point about the distinction between associating within and outside the cell. In a CSC, are the cells shared?
I'm not sure we know, my lord.
Right, so I'm just trying to understand the point you're making. Let's say under Rule 46, a prisoner is removed to a CSC and doesn't share a cell. That situation doesn't provide an inconsistency with the Secretary of State's interpretation. There's no association. I mean, I know they're defining it's outside the cell, but I'm just trying to understand.
Yes.
That wouldn't provide any inconsistency. There would be no association. Is that right?
Yes.
Yes. You seem to be making a point, which I'm sorry, rather slow in catch.
So, you should have in front of you, I'll come at it, you should have Rule 50, Rule 50B and Rule 53.
Right, we've got two sets of them.
Sorry, but it was my fault in the way I handed them up.
I'm just trying to. I'm sorry. I'm
Yeah,
being slow. I'm trying to pick up your point.
Yeah, but look, it's a point of just that if one is trying to understand what removal from association is concerned with, the Secretary of State's case is concerned with keeping prisoners apart
Disrupted prisoners.
and keeping them apart from other prisoners.
Partly prisoners generally. Yes,
Yeah. Our case is no, it's concerned with removing prisoners from normal association.
No, I understand.
If a prisoner in their cell with a cellmate is still removed from association, which, as we understand it, is the Secretary of State's case, that supports our interpretation of what removal from association is. Because if removal from association was concerned with keeping prisoners apart, then a prisoner who had a cellmate would not be removed from association.
That's why I asked the question. Whether, I mean, I understand the point.
Yeah.
That's why I asked whether, either in a CSC, they do share cells.
Well, I don't know.
Well, because unless they do share cells, I don't see where you get to.
Well, it's a similar question. We're talking that. Well, it's a question of statute interpretation. If association, as everyone appears to accept, means association outside the cell, we simply say that supports our interpretation of what removed from association is, because it suggests that what you're concerned with is where association happens, not just keeping prisoners apart. That's the only point I make on that. It supports that as being what removed from association is concerned with. Well, the second point is on the statutory language is the use of the phrase removal from. And we should hopefully have, say, 3 prison rules, 50, 50B and 53.
Yes.
And these do make provision for prisoners to be kept apart from all other prisoners. And we'll also see at 50, this is compulsory drug testing, 56 and 7. These are provisions that permit governors to keep prisoners apart from other prisoners. And this is for obvious reasons. This is in a drugs test. You have very similar provisions, 50B, 4 and 5 for alcohol tests. While you're waiting for a sample, you're able to keep prisoners.
How does this help us with construing the meaning of the words? association.
It's removal from, so I'm now on to removal from
Removal from
association.
association.
And it's this one. Again, the Secretary of State's case is that removal from association is about keeping prisoners apart from other prisoners. We say if that's what Rule 45 and 46 was concerned with, it would have said so. It would have said if it appears desirable for good order and discipline, a governor may arrange for prisoners to be kept apart from others. The fact that removed from association and kept apart are both used in the prison rules suggests they have different meanings. Kept apart, we say, is what the Secretary of State says removed from association is. Kept apart is kept apart from all other prisoners. Removal from association suggests taking the prisoner away from something. And we say that is what it means. It's taking the prisoner away from normal association and placing them somewhere else. It's not, if it was concerned simply with keeping apart, we say it would have said so.
Well, I assume that these rules will not necessarily come in together. They may have different, presumably, they may have different origins at different times. Do we know, are 50B and 53, are they part of a suite of provisions? They look as though they are dealing with supervision, restraint and drug testing. So they're a particular sort of suite of provisions. Is that right, dealing with that issue?
Yeah, 53 is in a different section. You see the heading there is offence against discipline. So they come from different parts of the prison rules. 50 certainly was enacted at the same time as, in those terms, as 45, 46.
Which one, 50?
50.
50.
Well, that's simply the wording removal from association. And we don't say it's absolutely conclusive. We do say if one starts to unpack what association means and removal from, it supports our interpretation, we say, rather than the Secretary of State. We do say the position is clear if one reads 45 and 46 as a whole. Turning first to Rule 45, if removed from association read removed from all association, we say a prisoner subject to Rule 45 would have to be permitted no association at all. But we know that's not the case. Prisoners subject to Rule 45 can be permitted, and in certain circumstances must be permitted, association within the segregation unit. Was described in the Secretary of State's guidance as mini association. In very much the same way as Mr. Syed was permitted within the MCBS unit. And we do say that is fatal to the Secretary of State's case. Because it must mean, we say, if a prisoner can remain subject to Rule 45 while being permitted to associate, provided it's within that unit, that can only be because removal from association does not mean.
So where do you get that from the rule?
My lords, I get it from, or I get it from, or perhaps I'll take my lords through three propositions. The first is prisoners can be permitted, prisoners within segregation subject to Rule 45 can be permitted to associate.
Yes, well, you gave that example of prayers.
Prayers, but my lords, also a further example is which I'll go to in a moment. Our second proposition is that those prisoners remain subject to Rule 45. And third proposition is that must be because removal from association does not mean removal from all association. I mean, also the prayer example is one, which is, we set out in our skeleton that prisoners who are segregated have to be permitted to attend weekly Sunday or Friday prayers, unless there is some exceptional reason not to permit them to do so.
It is attending weekly prayers association.
Well, yes, it certainly would be under Mr. Justice Lewis's definition. That's contact, interaction with other prisoners. My Lord, there's also within the guidance on segregation provision that makes clear that prisoners within segregation or within segregation units should be allowed to associate with one another. And you have in the Authorities Fund at tab 22 you have PSO, this is Prison Service Order 1700, which is the prison service order that deals with segregation. Unfortunately, there's only an online version, so that's why it appears in this slightly odd format. Tab 22. And it was page 9. You see the regime for those segregated under Prison Rule 45. And it there explains the regime for segregated prisoners under rule, this is the final paragraph, Rule 45, should be as full as possible, and only those activities that involve associating with mainstream prisoners should be curtailed. Various things that should be permitted, including one which is association within the segregation unit. And it's described later on page 13. The third paragraph describes it as mini-association, the kind of rewards, incentives that could be allowed. I mean, also the segregation process is described in similar terms. A couple of tabs back, you have the House of Lords Secondary Legislation Scrutiny Committee describing amendments to the prison rules. And paragraph 9 of that describes how segregation works. First, and again, we'll return to this point. The first sentence of segregation is the removal of prisoners from normal association with his or her peers. Again, we say that is what segregation means. And we'll also see the sentence, the MOJ states that segregation is not the same as solitary confinement. This is halfway along paragraph 9, which is never used in prisons in England and Wales. Prisoners located on the segregation wing are usually able to associate with other prisoners on the wing, provided it is safe for them to do so. And we say it's not only that that is how.
Is there any requirement that Rule 45 prisoners be allowed to associate with them?
Well, it would come from Article 8, because if you have a prisoner who.
I'll leave aside Article 8 in terms of the rules and regulations.
It doesn't state so in the rule itself, but one would have to, we would say, read the rule subject to Article 8, because if you have a prisoner who needs to be held it's regarded as appropriate to hold them in the segregation unit, but they can be permitted mini association, it will be inconsistent with Article 8, it will be required of Article 8 that they will be permitted to do so. So we do say if one reads Rule 45, how it has to operate, we say it's both, in practical terms, prisoners can be permitted, but also we say they must be permitted if it's safe to do so. And the same, my lords, with religious services, it will be a breach of Article 9 if a prisoner in segregation was not permitted to attend religious services in the mainstream prison when it was safe for them to do so. So again, you would have to interpret the prison rules in that way. Our second proposition is that a prisoner held in a segregation unit but permitted to attend Friday prayers or permitted some small amount of mini association remains held subject to Rule 45 and therefore to the protections and authorisations that it contains. We don't understand that to be disputed. I'll see in a moment what the Secretary of State does say on this point. We don't understand that to be disputed. And we set out at paragraph 31 of our skeleton why that must be right. That you don't lose all the protections of the Rule 45 process because you're allowed once a week to go to Friday or Sunday prayers. And my lord, that leads to my third proposition, which is that must mean, if you can be held subject to Rule 45 but permitted to associate in that sort of limited way, that must mean that removal from association doesn't mean removal from all association. And, my lords, what the Secretary of State says about this is in their skeleton argument, tab 20 of the core bundle, paragraph 23C. And this is dealing with the faith example, the worship example. It said, if the last two sentences, even if a prisoner in segregation is able to associate for 1 hour a week, this does not mean that he has not been subject to removal. This does not mean he has not been subject to removal from association. As noted above, Rule 45.1 does not prohibit any association by such prisoners. Instead, it authorises the absence of association. And that's referring back to paragraph 20. The last two sentences. Rule 45 doesn't prohibit a prisoner from associating with other prisoners. Instead, it authorises their holding. Now, as we understand that, Well, there's two possibilities as we understand it, and maybe I can deal with this better in reply. Either it's being suggested that a prisoner who is able to associate in that limited way is still removed from association. Well, that of course can't be right, because that would apply to Mr. Syed. He has that sort of mini association. Or it's being suggested that a prisoner can be held subject to Rule 45, but not actually removed from association. But again, we say that can't be right. It's quite clear that a prisoner can't be held subject to Rule 45 unless they are removed from association.
Well, is that right? I mean, 45 merely sets out what is necessary in order to remove something from association. It doesn't say that therefore that person thereafter, a special and unspecified authority, can never ever associate with anybody.
But
It's basically setting up the framework for saying what are the circumstances which you can remove somebody, isn't it?
well, it is, but what we say is once one ceases to be removed from association, the prisoner falls outside Rule 45. You can't be subject to Rule 45 and be permitted to associate.
Well, why not? Why not? Because you can any time be made to be removed from all association.
Well, if one turns to Rule 40, we say that, and that does depend on reading Rule 45, in particular 45 2 to 2C.
Where's the best place to look at that?
Tab 1 of the authority bundle has that. It's page 5. So yeah, I thought the heading is at the bottom of page 4. My lords, where one can test this out, the question is, does one have to carry on, which authorising reviewing once a prisoner is not removed from association? We say the entire scheme is premised on a prisoner actually being removed from association at the outset, then at 72 hours, then at 14 days, then at 42 days. If a prisoner is not removed from association, not in fact removed from association, none of those provisions then apply. That's what I mean by falling out of Rule 45.
So, how do we reconcile 45(1) with what you say is the right to allow people to go to prayers? Presumably, if you're a 45(1) person, the governor can say you shouldn't go to the prayers.
Well, yes.
Yes. So is what you're saying is that although the governor's taken the position, right, it is desirable that this person shouldn't associate, but there comes a time when they think it's going to be okay for them to associate with 2 or 3 other people, automatically fall out of 45(1). That's your point.
Yes, my lord. And 45(2) onwards. You can't be subject to the authorisation process if you're no longer removed from association. I mean, you can't be you're not subject to Rule 45(1) in the first place unless you're in fact, or 45(1) gives a power to arrange for removal.
The alternative way of looking at this is that you are subject to Rule 45 because the governor has imposed it, and then there is a liberty of the governor to allow certain privileges at his discretion.
Well, yeah, but we say that doesn't fit with the wording used. The wording envisages removal throughout, and that's how you measure when you get to 72 hours. And we'll see in a moment, that's certainly how the prison service order interprets Rule 45. It doesn't interpret as being an authorisation and then the governor can decide, subject to that removal, to move you back onto a normal wing back into segregation, allow some.
Presumably there's some sort of order made, is that right? Rule 45. Or some direction.
45, there's no formal direction, simply that if it's desirable, the prisoner can be removed. So the starting point is simply the governor removes the prisoner from association.
But then there are a series of authorisations and the one outside the process as well.
There's one at 72 hours. The first one is simply the removal. There's a 72-hour authorisation, 14-day authorisation, and we say that is the ordinary meaning of that language is that a prisoner is, you get to 72 hours of removal.
But once there's an authorisation, during that period you're simply subject to that authorisation of removal. It require you to actually be removed.
Well, we say that the straightforward reading of it, and our reading of it, is that if a prisoner is, after 24 hours, allowed association, put back onto the normal wing, you can't then remain subject to, you don't get to the 72 hours, you don't get to the removal for more than 72 hours suggests that you are removed for that period. If after 24 hours you're no longer removed, you don't get there. That's our submission.
What about 45(3)? The governor may arrange at his discretion for prisoner removed on this route to resume association with other prisoners at any time. It gives a general liberty.
Well, it does, but we say once you're back.
No, it doesn't say back, and that he's removed the removal from association. It simply says there's a discretion for a prisoner who is removed, i.e. by definition subject to Rule 45, may resume association with other prisoners at any time, i.e. you can go to prayers or you can have a mini association. Isn't that how it's supposed to work?
Well, yes, and we accept that is how it's supposed to work, and we say that prisoner remains removed from association because they are removed from association, they remain subject to mini-association, subject to, or remain permitted mini-association and allowed to go to prayers. But we do say that's how it works because that prisoner remains removed from association. If a prisoner is put back, on the Secretary of State's case, you have to be able to put a prisoner back on the mainstream wing after 24 hours, but say, we still think it's desirable for you to be removed from association, therefore we keep the authorisation going. We say the regime only works, or only makes sense, if it is desirable to remove the prisoner from association and remains desirable. If it ceases to be desirable, and the prisoners return to if the prisoners return to association, we say they fall outside of this regime. And well, certainly that's how Prison Service Order 1700 understands it's back in tab 22. And after the internal numbers ends at 73, you'll see there's another document which is the part that deals with reviewing and authorising continuing segregation.
So what is the status of this document?
These are prison service orders, which is guidance produced by the Secretary of State. And this indicates how the review and authorisation process operates. And also the first point, you'll see just in the title to it, is it's reviewing and authorising continuing segregation. And we say that is what it's concerned with. There has to be continuing segregation for this for one to ever get to a process of review and authorisation. And we'll also see, turning onto the first page 1,
Yeah,
1.3, my lords, will see how segregation is understood here. And we say, again, this is what we say is the correct interpretation of it. 1.3, this document applies to a prisoner who is segregated and is denied normal association with the mainstream prison population.
What page are you on?
Page 1. Does my lord have the document that's... It's after page 73. The next page is the title, which is Reviewing and Authorising Continuing Segregation. And this deals with that process under 45.2 to 2C. And we say it is precisely concerned with continuing, not those who are permitted, who are no longer removed from association. And when I was at 1.3 on page 1, while you have this open, we say that description of segregation, we say is the correct one. Denied normal association with the mainstream prison population.
Well, that's true as a matter of fact. It doesn't mean that's what segregation means.
Well, it does, but we say that is what it means. That's what it means for a prisoner to be segregated. It doesn't say in this document or in any others, as far as we're aware, that it means prevented from having any association with other prisoners. And we'll also see 2.2, the role of the segregation review boards. And it's a segregation review board that gives the initial authorisation at 72 hours on behalf of the governor, and then at 14-day intervals. And the description of what they do, we say, is entirely consistent with what we say, how we say the rules ought to be read, is you're concerned with for and against continued segregation.
So where are you reading from?
2.2. Decide whether all relevant issues must be considered regarding the options of either extending segregation or removing the prisoner from segregation. The harm if you remain segregated, etc., or return to normal location. And there's no suggestion at all. We say that is how the rules would ordinarily be understood. That is what the Segregation Review Board is considering. It's not considering a prisoner who is permitted to associate. There's not a third category. A prisoner is either segregated or not segregated. And to go through all the authorisation process, or one goes through the authorisation process when a prisoner remains continuously segregated at 72 hours. And that's repeated again under 2.8, the timing of review boards. The premise there is that the prisoner is segregated, removed from association throughout. 2.11, subsequent SRBs every 14 days throughout the entire period during which the prisoner is segregated. And similarly, the 42-day stage, this is when the Secretary of State decides, or the Secretary of State's authorisation is required.
Yes.
Again, it's authorisation for continuous segregation beyond 42 days.
So which paragraph is that on?
3.1. And we do say, my lords, that that is how the regime is intended to operate, namely that prisoners can be permitted, and indeed must be permitted in circumstances, mini-association. They remain subject to Rule 45 and all the protections that accompany it, but that is because they have been removed from association throughout. That's what triggers the authorisation review process. And we also say, my lord, that must be the correct interpretation, because if one thinks about how the regime would operate if the Secretary of State was correct, it would be this: if you have two prisoners and the governor thinks they're being disrupted, they need to be moved out of the normal prison population. If in relation to one prisoner, the governor decides the next day, well, this prisoner should be allowed to attend Friday prayers or should be permitted mini-association, and then the prisoner remains on the segregation unit for the next 6 months, that prisoner is entitled to all the panoply of protections under Rule 45, 72-hour review, etc. Now imagine the second prisoner, the Secretary of State decides at the outset, the governor decides at the outset, this prisoner needs to be removed from the main population, but I think it's fine for them to attend weekly prayers. I think it's going to be fine for them to interact with other prisoners in the unit. That second prisoner can then also be held for 6 months, but without any of the protections, entirely outside of the Rule 45 regime. That prisoner, according to the Secretary of State, has never been removed from association.
I'm not sure I got a clear note of your summary of how you say the regime is intended to operate. Could you just dictate the proposition again to us as how you say the regime is intended to operate?
The prisoners held under Rule 45 can be permitted association within the segregation unit and potentially at prayers. Those prisoners remain subject to the authorisation and review process. That is because they remain throughout removed from association.
Well, yes, I think what you say is that association in Rule 45 and Rule 46 bears the same meaning as you showed us in EA22, document at the end. That it means normal association with mainstream prison population. You say that's exactly what it means.
Yes. Yes, and removal is removal from that.
Yes. Association means that, and therefore removed from that is anything less than that.
Oh dear. And so we say the fact that prisoners are able to associate while remaining subject to Rule 45 must be because it does not mean, removal from association does not mean removed from all association. And as I say, if that isn't right, you do have this, we say, very odd position that if the governor decides at the outset this prisoner needs to be removed from normal association, but at the outset decides they ought to be permitted to attend prayers, they are never removed from association. That must be the Secretary of State's case, because at least the Secretary of State's case is that certainly at the outset it has to be desirable to remove from association. And if the governor decides a prisoner should be permitted some association, on the Secretary of State's case, they're never removed. They never get into Rule 45. we say it can't be right that if the governor makes that decision the next day, you do get into all of the different review process and
Well,
protection.
I think you'd say, correct me if I'm wrong about this, you'd say if the Secretary of State is correct, it means that, first of all, the moment there seems to there is an association, some sort, let's say Sunday prayers, Friday prayers, new associations, you say you would fall logically outside the Rule 45 area. And so you've got a group of people who are falling between two different stools. You've got the mainstream prisoners, the normal ones, and then you've got the ones at the other extreme end, which is the Rule 45 ones, and then this group in the middle who are not being permitted to associate with the mainstream aren't subject to Rule 45, and therefore the only thing governing what they can and can't do is Article 8.
Yeah, well,
I mean, I'm just trying to follow through
Yes.
your submission. Is that right? Is that what you're saying?
we say that those...
You end up with a kind of anomalous group of people who are neither mainstream nor Rule 45 because they do associate.
Well, no, sorry, but
This is on the Secretary of State's case.
yeah, yes, exactly. You would get exactly. Whereas I think that,
I'm trying to-
yes, but on the Secretary of State's case, you end up with this group of people in segregation
in the middle,
units.
in the middle area,
Yeah.
who are neither one extreme nor the other. They're not normal. They're not Rule 45. There's nothing, as it were, specifically laid down governing what the governors can and can't do, but they are restricted.
Yes,
is
but
that right?
well, it is. But what the Secretary of State says is actually these people are subject, he says,
No,
to
I
Rule
understand.
45.
I understand.
And that's where we get the anomaly. Well, precisely, yes. If,
And I'm just
yes,
trying to build on
yeah.
what you said.
Yes.
Is the logical end result
yes,
of the Secretary of State's position.
yes. As I understand it, his position is those prisoners within the segregation do in fact remain subject to Rule 45. And we say that's inconsistent with the language of the rule. So that can't be the answer. We say the answer is removal of association means removal from mainstream. And my Lord, in terms of authority on point, there isn't anything we say directly on point, but we do say the Supreme Court decision in Shahid, we say supports our interpretation that a prisoner permitted mini-association remains subject to removal from association. And my lords have Shahid at tab 12. And we'll also see the factual background of paragraph 1 and paragraph 2. He was removed from association, placed in solitary confinement, otherwise described as segregation, on the 7th of October 2005.
Paragraph 1, on page 441.
Page 441. Paragraph 2 is the...
Paragraph 2.
Sorry, paragraph 1 is just the background. His next offence. And you see, he's subject to continuous segregation for 56 months. And it's important, we say, that the Supreme Court considered that he was subject to removal from association, continuous segregation for that length of time, for 56 months. And the Supreme Court then considers whether he's being held in breach of the Scottish equivalent of the Scottish prison rules. And we'll also see at paragraph 7, Rule 94.1 is not identical, but it's fairly similar to 45.1. Permits removal from association where appears desirable. And there's then a slightly different authorisation process, 94.5. And what's found, for reasons I don't think we need to go into, that some of the authorisations were late, and so it ended up being that his continued removal from association was not properly authorised under the Scottish prison rules. And it's then concluded, my lords will see at paragraph 91, because some of the authorisations were late, because some of them hadn't been made properly, he's being segregated without lawful authority for, I think it worked out as about 15 months of the 56. But significantly for our purposes, it appears that Mr. Shahid was held in what looks like very similar conditions to Mr. Syed. If you turn back to paragraph 33, you see paragraph 33 describes the regime, and it's, again, the second sentence, we say that is what segregation is concerned with. The regime prevented contact with the general prison population. It did not involve the appellant's total isolation from other prisoners. He was permitted to associate with other, he was confined to his cell for between 20 and 22 hours a day. He was permitted to associate with other prisoners at times when he was released from his cell, at times when he was released from his cell. And on the Secretary of State's case, he was not removed from association. He was not subject to removal from association. He was not subject to segregation because he was able to associate in those short periods of time outside his cell. And it's clear that's not how the Supreme Court analysed it. In fact, the case would have been wrongly decided if that was right, because he wasn't being removed from association without lawful authority. On the Secretary of State's case, the reason you end up with that, the outcome that you do, is because the Supreme Court obviously considered that he was not just subject to authority for removal from association, but actually removed, because otherwise it wouldn't have been unlawful. And you'll also see, my lords, at paragraph 77 onwards, sets out the various concerns about the impact on prisoners of prolonged segregation, various well-known findings of different reports. Again, none of that would make sense if, on the Secretary of State's case, Mr. Syed simply wasn't segregated. We say he was subject to removal from association, was subject to segregation in precisely the same way as Mr. Syed was. Also similar, time out of cell, away from the general prison population. Well, that's Rule 45. Rule 46 one of the key reasons that Mr. Justice Lewis found against us below was the provision at 46.3. Which permits a direction to be made that prisoners resume association within the CSC or elsewhere. We say, again, similar to Rule 45, the fact that prisoners are able to associate within the CSC while remaining subject to Rule 46 helps our interpretation rather than the Secretary of State's. And also the reason for that is this: if one looks at 46, empowers the Secretary of State to make a direction, and you can make that direction if it appears desirable that a prisoner shouldn't associate with others. So that's the condition for making the direction. And then the direction is twofold. It's direction for removal from association, and then it's a direction for placement in the CSC. And also, (46.2) then makes provision for continued authorisation. You can renew the direction under paragraph 1 after a month, and each month. So if you have a prisoner who is placed in the CSC and after a week is permitted, as appears normally to be the case, to associate with other prisoners within the unit, you then get to the end of the month and a determination is made as to whether to renew the direction. And we say that if removed from association meant removed from all association, you wouldn't be able to renew the direction. We say the direction in 46.1 has two elements. It's direction both for placement in the CSC and for removal from association. You have to have both. And furthermore, the criteria has to be that it's desirable that the prisoner be subject to removal from association. And if you're renewing that direction, you must be making the direction again. But as I say, that direction is a direction for removal from association. So you could not make that if the Secretary of State is correct. Because it's not desirable that the prisoner be removed from association, and you're not directing their removal from association. We say, if our interpretation of removal from association is correct, there's no difficulty with that. A prisoner is able to remain in the CSC. You can renew the direction because you still consider it desirable for him to be removed from association. You can direct again that he be placed in the CSC and subject to removal from association under 46.1, while at the same time permitting him association within the CSC. Lords, that's why we say if one reads rules 45 and 46 as a whole, and particularly how the authorisation process is intended to operate, we do say that it must mean that removal from association is not removed from all association, that the prisoners permitted to associate within the CSE, prisoners permitted mini-association, all remain subject to removal from association, and that is because we say it means removal from normal association, not all association. And my lords, we do say it is striking that in all of the Secretary of State's descriptions of removal from association or segregation, it is all described as being removal from normal association. Not removal from all association. And you've already said, I've taken you to where that's set out at paragraph 1.3 of Prison Service Order 1700. That's also how it was described when amendments were made to Prison Rule 45 to bring in the authorisation, or the enhanced authorisation process that followed the decision of the Supreme Court in Bulgas and Hussain. And we've set those out in our skeleton. I won't necessarily take you to them. They all appear in the same language. I took you, I think, to the House of Lords Secondary Legislation Scrutiny Committee description of the prison rules. Segregation's removal of a prisoner from normal association with his or her peers.
Can you remind us which paragraph in your skeleton?
Yeah, sorry. 44. And there's a pepper and heart objection to one of them, but they all say pretty much, I won't die in a ditch on that, they all say pretty much the same, they all describe segregation in pretty much the same way. And below, Mr. Justice Lewis declined to accord any weight to those various statements. We do say they're significant for three reasons. Firstly, and perhaps it's just a jury point, that it is striking that that is the way in which the Secretary of State describes segregation removed from association repeatedly, not as removed from all association. But secondly, perhaps more significantly, perhaps more substantively, one of the arguments put against, or made against us, is your definition of removed association is unworkable because it's not clear what. It said it's likely to lead to confusion and potentially inconsistent application because normal association is an unclear concept. We say the fact that it's used in guidance to prisons, used repeatedly by the Secretary of State, indicates that it's well understood what normal association means. And it's well understood what it means to remove a prisoner from normal association. It doesn't, as I say, mean some very specific, it's not a specific defined number of hours, some absolute number, precise number of prisoners, but it is association with the mainstream prison population for, it's normally most of the waking day, with tens of other prisoners. That's what normal association means.
So any departure from that regime is removed from association.
Any departure from normal association, as I say, but it's not, you have to have associated with 45 other prisoners, but if you take prisoners away from that regime, we do say that is how removal from association is understood.
What about temporary limitations because there's been some infraction? How does that work?
Well, so the various examples are put against us. For example, a prison lockdown.
Yeah, I'm talking about an individual who's being disciplined and therefore subject to a slightly different regime for a few days in relation to that infraction. That would. How would that work under your construction? Would that be removal from the mainstream?
Well, I'm not sure if that is the way the prison regime operates. That you have a somewhat that you can remove to some extent. If on a normal understanding you remain part of the mainstream prison population, no. Again, it's not a. We don't say there's some absolute number of hours, but if a prisoner is associating for large portions of the waking day, then they're on normal association. Well, it may be the answer to this is that ultimately the point is a Padfield one, is are you running contrary to thwarting the statutory purpose? There may be borderline cases where it's not exactly clear whether a prisoner is or isn't removed from normal association.
My Lord asked you whether any departure from the mainstream would violate, and your answer was...
Any removal from the
Any
mainstream?
removal?
Yes.
And your answer was yes.
Yes.
Depends
Whether if you remain on...
Depends what a removal is.
We say it's taking the prisoner away from that.
So to a hospital unit.
Well, so a hospital unit would not be because a hospital unit isn't removal for good order and discipline. That's the 45 and 46 process. And again, that's why it's a Padfield point. You're not removing them for good order and discipline, but outside of the regime. But hospital provision would equally cause a difficulty for the Secretary of State's description. If you lock a prisoner alone in their cell, or a prisoner is alone in a cell or can't leave their cell in a hospital unit, on the Secretary of State's case, that prisoner is removed from association because they're not able to associate outside their cell with anyone. So there are going to be borderline cases on both definitions.
He's removed in his own interests, isn't he?
I suppose, but perhaps he would be in those. Well, as I say, that still leads to the same difficult borderline question on the Secretary of State's case, because that prisoner, if that prisoner is placed in can't leave or is placed in a cell in a hospital wing on their own, so unable to leave, they're removed from association on the Secretary of State's case. So again, there may be borderline questions as to what exactly constitutes removal from association. But our case is that Mr. Syed's case, like Mr. Shahid's in Shahid, is not a borderline case. That clearly is, we say, removal from association, removal from normal association, which we say ought to happen subject to the statutory regime. Another example given against us is lockdowns. So what happens if you need temporarily to have a lockdown in the prison? But again, that's equally a difficulty for the Secretary of State's interpretation, because if you can't let a prisoner out of their cell, on the Secretary of State's case, that is removal from association. Again, it's another example of a potentially borderline case that may be difficult, but you will get those cases. But that doesn't, we say, tell you exactly what the underlying meaning of this phrase is. Most finally, on the underlying policy or the purpose behind Rules 45 and 46, they're these ones. Ordinarily in a prison, including in the high security estate, and including prisoners convicted of the most serious offences, prisoners do have a broad opportunity to interact and socialise with a significant number of other prisoners. In education, in formal association time. And we say that is of real importance to prisoners. When so much of a prisoner's freedom is taken away, the ability to develop relationships, interact with a range of people, choose who to speak to, who to build friendships with, is one of the few aspects of personal autonomy that's left. And we'll see when we look at the Article 8 case law that that is why removal from association in all the Strasbourg and domestic authorities is regarded as an interference with Article 8 because of the importance of that aspect of personal autonomy for prisoners. And we of course accept there are prisoners for whom that sort of association will have to be removed on a short, or prisoners will have to be removed from that sort of association on a short or long-term basis. And the purpose of Rule 45 and 46 is to make clear that that can lawfully happen and to set up safeguards when it does. But we say that purpose wouldn't be fulfilled if a prisoner who was permitted very small amounts of association would fall entirely outside of that protective regime. If they're permitted to attend prayers, if they're permitted an hour or so of association a day, as with Mr. Syed, as with Mr. Shahid, it appears. All the underlying reasons why there are protections in removal from association cases apply equally to them. Particularly where prisoners, again, as here, can be held for months and years in those conditions. Well, unless I can assist further, those are...
Thank you very much.
Our basic position, as you understand, is that the judge was right for the reasons he gave. So I can take it pretty shortly, I think. We are dealing here with a location, the MCBS, in a particular unit or part of the prison considered to be appropriate to the risk posed by prisoners such as Mr. Syed then was. It is perfectly clear on the facts that there are less opportunities to associate with prisoners in the MCBS than there are in other parts of the prison. That's clear from the findings that the learned judge made. It's 8 hours or whatever it may be versus a much smaller number. It's also apparent that in that unit you are allowed to associate, subject to the strictures and the conditions that apply in that unit. And again, that was subject to clear, undisputed findings by the learned judge. We also know that there is another unit called a CSC in which you are genuinely segregated, where you are not allowed to associate. That is the general prima facie position. And you could, in theory, I suppose, have a prisoner in the MCBS who was subject to Rule 45, who is also subject to, as it were, the general position that he's not allowed to associate. But that's the essential factual structure. I didn't want to go back into the facts to any sensible degree, but just in the light of my learned friend's opening remarks on the facts, a couple of things, a couple of references perhaps will do it. So far as the MCBS and...
Can I just pick up on one point?
Yes.
You say in the case of segregation units, there's real segregation isolation. Of course, as has been pointed out by Mr. Squires, 46.3 specifically envisages that there may be some association within
Certainly.
the CSC.
Certainly, and I will come back to that because 45.3, as my Lord Justice Haddon Cave also pointed out, does exactly the same thing in slightly different language, but you can't get out of the fact that 46.3 is actually referring to prisoners in the CSC. I'm going to come back to that because that's the central plank of my learned friend's argument, and I'm going to take that head on if I may. I was just trying to paint a picture of what was effectively common ground to frame the issue of principle and interpretation that arises. And if I may, just by way of doing that, my learned friend took you to the report at tab 18 of the authorities bundle. Remember the report saying this is extreme imprisonment or whatever it was in tab 18.
Yes.
And that refers to, he said, to the MCBS, so take that as governing the conditions. You just need to exercise a little caution with that, and that is because that report describing the conditions in the MCBS and indeed the CSCs predated the relevant period that we're concerned about, which is effectively 2016, I think, when he was transferred from the CSC to the MCBS.
He was transferred from segregation.
Transfer from segregation to that, yeah. But the conditions in the MCBS, is the short point, have changed since that report. See, for that purpose, Mr. Waldron's first statement behind tab 2 of the supplemental bundle, paragraphs 8 and 9, for some of the detail of that. And that fact that the conditions had changed to some degree is acknowledged in the learned judge's judgment at paragraph 16. And if you want a summation, I hope a convenient summary of the nature and conditions in the MCBS to which Mr. Syed was subjected, those are perhaps best found in our skeleton on the Article 8 issues. I'm afraid they're both called Secretary of State's replacement skeleton rather inconveniently, but the one about Article 8 does contain a summary of the conditions and gives you citations into the learned judge's judgment and indeed quotes from an extract. So that's the place to go if you want a summary.
But do you take issue with the words in the light of those changes? Do you say that the description in the HM Chief Director of Prisons document, this is extreme custody, is not correct?
Well, my lord, I do, but I don't want to get sucked into a quibble about the adjective, as it were. No doubt it is more extreme than the conditions on the wing and less extreme than the conditions in the CSC. I'm not sure, with the greatest respect to him, that, although he's no doubt trying to reinforce a point, I'm not sure for present legal purposes that adjectives, my disputing or agreeing with that adjectives matters terribly. We know that the MCBS sits between the CSC and the ordinary wings, if you will. I hope that's not too fudgy an answer, but I don't want to engage in a spat with the learned inspector. But if you want the full summation of the nature of the conditions and how long he was allowed to associate for and the bands of prisoners and all of that, I hope we've fairly and completely set it out in the Article 8 skeleton.
Is that paragraphs 14 to 17?
Yes.
And also 18 deals with how much to say.
Let me just check.
14 to 18.
Yes. Yes. yes, it is. It's principally there, and you can expand it a bit at either end, if you will. Paragraph 3 and following describes how he got there, as it were, and paragraph 18 sets out with some specificity, by quoting from the judgment of Mr. Justice Lewis, the various bits and pieces about how he was to associate when he was in the MCBS. So it gives you the detail of the two prisoners, the three groups of prisoners, the two groups of prisoners, and so on. I hope that's a helpful and fair summary. And still on the same theme, if I may, there are plainly differences between the CSC and the MCBS, for understandable reasons. That is so, and a summary of their basic nature you can find in, again, Waldron 1, paragraph 18, behind tab 2 of the supplemental bundle. And if you just take up the document to which my learned friend did take you in the authorities bundle behind tab 27, you will see, I hope, quite a helpful summary. This is the, you'll recall, this is the Directorate of High Security policy document. But you'll see quite a helpful summary, I think, in the first half of page 5. So tab 27, first half of page 5, of the differences between the two when trying to describe which prisoners fall under the MCBS regime. So you've there got, as it were, the contrast of two regimes put side by side.
Sorry, James, which page?
Page 5, sorry, tab 27, first half. And it may be that the most crisp description of it is halfway through the second paragraph of that little section. The MCBS bridges the gap between segregation units and the CSC system, and so on. So it's, as it were, deliberately set up and designed to be a looser regime than the CSC, and it provides, if you will, the stepping stone between proper segregation in a CSC unit, if one's talking about the physical units, and then back to wing and full association. I think my learned friend said there were no criteria in here for who falls within that regime. You will see the description I've just taken you to on page 5, and you will also see on page 15, at the top of the page, under the heading Referral Criteria, page 15, so you've got a basic description, but it is intended to be, if you will, a halfway house.
But it's not a gap between segregation units and the CSC, it's a gap between the normal wing and the CSC.
It is. It is. So can I turn then to the meaning of the rules, which is really the stuff of the debate. You know that both Rule 45 and Rule 46 contain, in effect, mirroring concepts. Should not associate with other prisoners is one, and removal from association is another. And the latter, removal from association, is in effect, under the structure of those rules, the consequence of the decision that it is desirable that the former should occur. But the basic nature of Rule 45 and indeed Rule 46 is critical to the correct interpretation of the rules we submit. And the basic nature of the rule is that it authorises. It is fundamentally an authorising rule. The governor may, and then there's a process for renewing and revisiting at regular intervals, but the governor may remove from association. So it authorises prisoners to be held in conditions in which he does not associate with other prisoners at all. And in that sense, it is indeed the taking away of the opportunity to have contact and to interact with other prisoners, but it's an authority to do that. It doesn't prohibit some interaction. Indeed, in terms, it expressly permits a loosening of the reins, if you will.
But it only applies, the authorisation only applies where it is desirable for the maintenance of good order or disciplinary's own interest.
For the person to be removed, for that general authority to be in place.
Yes.
You can remove subject to relaxation. So you can segregate. If one stands back from it and treats it not so much as an intellectual black letter exercise, but stand back and say, what is the function of this in the overall prison scheme? It is to authorise people to be segregated. It's no accident, you've seen in our skeleton, it's no accident that the courts have repeatedly, as it were, elided the two, segregation or, in other words, removal from association. But what this rule is doing is to authorise a position in which the prisoner who is subject to the rule can, in effect, be deprived of association in its entirety.
There's no dispute about that. There's no dispute that's what it's aimed to do. It's an authorisation. The only question is, does it mean that it only continues so long as that purpose continues?
Well, I think my learned friend says, we know the nature of the dispute, my learned friend says that what this means is normal association.
Yeah.
So any removal from normal association. And we respectfully submit that that isn't a natural reading of the words. The natural meaning of the words is that removal means removal from association. But there isn't then the false dilemma which my learned friend's submissions this morning and indeed in his skeleton have ascribed to our position. Because once you understand that it is simply authority to remove from association in its entirety, then you can perfectly consistently have going to chapel or limited association conferred, as it were, as a privilege within that regime, because the governor will then have the option, as it were, to remove the privilege to go back to complete absence of association. So this isn't a rule which, if operated, requires no association.
It isn't an all or nothing rule. It authorises, and the governor then has a discretion, an option.
Exactly, and that exactly so.
Excursions from that.
And that's evident from the reading of the rules as a whole. That's the significance of subparagraph 3, amongst other things. But so you have an authority, you then don't have the false dilemma, because it's perfectly consistent to say that when someone is subject to Rule 45 or is in the CSC pursuant to Rule 46, the governor is always able to remove association in its entirety. And that, of course, is not the position in the MCBS. It could be if a prisoner was subject to Rule 45.
No, I understand that. I understand if you read it that way. I understand the proposition that read literally, removal from association is not qualified by the words normal or anything else. I understand that point. I don't think there's necessarily any dispute about that, but that seems to be one matter. One can quite see that it would operate, from your perspective, perfectly well if it had the meaning that you say. The question is whether, giving this as a purposive interpretation that works in practice, you have to add something in. And the first question, really, it seems to me, at any rate, one of the questions is, once it ceases to be desirable for the maintenance of good order or discipline or whatever it may be, that there should be no longer any association, what is the position? If the interpretation is that removal from association means from all association, and that ceases to be the case at any moment of time, then on the face of it, 45 ceases to apply.
But it doesn't cease to be, for good order and discipline, if one takes that example, it doesn't cease to be desirable just because a prisoner is allowed limited association. It remains desirable that the governor should have the opportunity and the ability to pull that, if you will, to go to a place of removal, to go back to a place. That's why it's critical to understand that it's not prohibiting association, it is conferring an authority to move to that place. So you can move back from it to a limited association, you can allow the chapel, you can allow limited association, even in a CSC unit, perfectly contentedly, under 46.3. But you can still go back. And so the authority remains. So I think the answer to my Lord's question is perhaps that it doesn't follow, as my learned friend appeared to be suggesting, that the thing ceases to be desirable. The Rule 45 order ceases to be desirable on our understanding of it and our interpretation of it. It doesn't cease to be desirable just because the prisoner is allowed limited association, because the continuing effect and desirability of having that power is that you can revert to that place.
Well, I understand that's what you say, how it should operate. But let's say within the period of 14 days under 2A, it's been renewed for a period of 14 days. And after the within the 14 days, it's thought, okay, now this person can associate with others on a limited basis. Can it be said at that moment of time that it is desirable for the maintenance of good order or disciplinary interest that the prisoner should not associate, in your case, at all, with any other prisoner? Answer, no. Can't be said at that moment of time.
Should be removed from association.
Yes, because they've just been allowed to associate.
Well, yes, it can. It doesn't mean normal association, as my learned friend asserts. It means limited association with a permission still to go back to a place of no association. So if you are the governor and you get to 14 days and you say, actually, I think it's desirable now, he's been in here for 14 days, he's been good behaviour, he can associate for an hour. Yes, if that's the position, it still remains appropriate for the Rule 45 order to remain in place, because removal from association and association allows for that. And it allows for that because what this rule is doing is to authorise that position. The fact that it authorises that position in general terms does not imply that it could not be made subject to exceptions. And if there were any doubt about that, and no doubt this debate indicates that there might be, that's why 45.3 and 46.3 exist, to put beyond doubt that you can have limited association within a Rule 45 regime. On my learned friend's case, which was the point the judge made, he says that he has to say that the rules in their structure are incoherent because they're internally inconsistent. And that is a nonsense, I respectfully submit. And the reason it's a nonsense is because 46.3 and 45.3 are absolutely clear. You can make limited exceptions within a regime in which it continues to be desirable for the governor to have the authority to revert to no association, to removal from association. So that is the trigger. But it's the nature of this rule as an authorising rule that means that the dilemma that my learned friend poses is false. So if you take his 3 steps, as it were, we certainly agree with 1, we certainly agree with 2, we may agree with 3, but it doesn't lead to the place he wants to get to.
At what point of time do you have to satisfy 45.1? Is it only once off, the very first time, and not after that? His authority, the governor's authority, to arrange for the prisoner's removed from association, on your interpretation, when does that have to be satisfied?
When he does it.
So it's being done. It has to be done on a series of different occasions.
Yeah.
So it does have to be satisfied by the end of the 74 day, at the end of the 14 days, and then at the 42 days. So you're satisfied, it has to be satisfied then, but it doesn't have to be satisfied at any intermediate point. I think it's effect you're saying. You're saying, well, yes, every time the governor has to make a decision, yes, you have to be within 45(1). But at any moment in between, it doesn't matter whether that's there or not, because it's an authorisation provision.
Well, sure, I am saying that.
Well, that's what I'm trying to understand.
No, my case is the broader one, which says he does indeed have to apply the test of desirability for the maintenance of good order and discipline, or in his own interests, that the person shouldn't associate.
Yeah.
He has to be satisfied about that before he can remove him. If he is satisfied about that, he may arrange it, 45(1). The test isn't then repeated for the authorities that then follow at the various points in time, but the same test would need to be applied.
Take 2B. The governor must obtain leave from the Secretary of State in writing to authorise removal where the period amounts to more than 42 days, can only give a maximum of 42 days, but he can be renewed.
Yeah.
So just so we understand this, so your case is, as I understand it, it's only at the very first stage that you have to satisfy the condition. It doesn't have to be satisfied thereafter, either by the governor or by, in this particular case, the Secretary of State.
I say it has to be satisfied throughout, and the test, I say it has to be satisfied throughout, and the test has to be specifically addressed by the relevant people at the relevant times specified in the rule thereafter.
Right.
My point is a more basic one, which is that what this rule is doing is to authorise the governor, the prison, to hold a prisoner in conditions in which they can be segregated, and that is not, i.e., no association at all. And they always have that authority, so they have to be satisfied that the prisoner, at all times, when he's subject to Rule 45 or in the CSC under 46, at all times they have to be satisfied that it's necessary that they should have that authority, i.e., to withdraw him from association entirely. But that is not inconsistent, I respectfully submit, and indeed it would be surprising if it was, that is not inconsistent with the governor also having authority to permit some form of limited association pro tem, if you will, as a privilege, which can then be withdrawn by him if he considers it appropriate. That's how I put it. So I don't put it as a, you just have to satisfy it once and thereafter it's free to the wind. I acknowledge.
But I think what you're saying, what we do have to be satisfied, I think I've taken this down correctly, it is necessary at all times, it is necessary at all times for the governor or Secretary of State, for the governor to have the authority to withdraw from association.
Yes.
That's the way you put it.
Well, it's necessary for, I put it, I think, slightly differently, and forgive me, it's my fault. They have to be satisfied about the legal test set out in the rule, and that's that it is desirable, on one of the grounds set out in 45(1), for that authority to inure.
You have to be satisfied with the legal test, that's under 1.
Exactly. At all material times when the person is subject to Rule 45.
But that's, I think, what I
Yes,
put you.
but that is not inconsistent. My learned friend's case is, well, it must mean normal, because that would otherwise be inconsistent with any permission, whilst that authority continues to exist, with any permission being given to authorise any form of association at any time. And my submission in answer to that is that demonstrates no inconsistency. It can still be necessary to have that overarching authority based upon a satisfaction of the legal test at all times, while still allowing, as it were by way of privilege, some very limited form of association.
So if I recall this as you have to be satisfied of the legal test in 45(1) at all times.
Yes.
But 2, that is not inconsistent with a discretion to allow limited association.
Exactly so.
That's the effect.
Exactly so. And what you can add to that if you will, because both sides are playing hard against the other one's case without addressing their own, perhaps. But you can take from that an additional submission, which is that you don't therefore have to, as it were, imply the word normal into the rule. This is my learned friend's case. But that's the essential nature of this, and that's why we say you can and should approach removal from association in its normal sense, in its normal natural meaning, which is removal. You take it away entirely. That's why the courts in all the cases we referred to in the skeleton say segregation or removal from association, because removal means removal. But it's a removal which is authorised. It's an overarching authority for as long as they're in there.
And you presumably say that there's an obvious practical purpose behind the construction of the rule. That it gives the governor complete control from which he can then derogate. You could have a different rule which allows iteratively to take this privilege away or that privilege.
I do.
This is a clean rule which has an overarching provision, removal from association, from which the governor then has discretion to allow certain privileges at his discretion.
My lord, I do. That was going to be my point one, as it were, under purpose. If one stands back from it and examines the rule from a purposive perspective, that's a readily intelligible intelligible approach. It doesn't do damage to any set of rights or indeed policy, create any policy difficulty. The second point, under purpose, if one's moving to that, is that there is no such thing as normal association. So if you put normal association in there, this is a rule. Of course, people in debate will refer to normal association. Everyone understands roughly what that means. But this is a rule which contains its own process, creates its own administration and need for various parties to get involved. And so you need precision.
When you say that, but I mean, the point again that's made against Ordinaire is that the NOMS service itself uses the expression normal association with the mainstream prison population in its own policy document.
It does. It
That's
does.
Not a debate. That's not a debate. People aren't debating. That's the expression that they use.
That's true, but they're not using it for the purpose of operating in a rule such as this, as a legal trigger. It's a very, very different thing indeed to use that sort of phraseology in a policy document or a description document or a debate, as compared to actually introducing it into a rule where you're required to know, black or white, am I in it or am I not? That's the point we make about interpretation on that. And as Lord Reid made very clear in the Borgas decision, I don't take you to it, we've cited it and quoted it in para 14 of our interpretation skeleton, there isn't any right to any particular level or nature of association. And so what that does is to create a principal problem for my learned friend. How then does the trigger within Rule 45 or Rule 46 or wherever you're going to introduce this concept actually work? So there's a problem with it from that perspective. How can it operate sensibly without a clear definition of what amounts to normal association, so you know whether you're in or you're out?
Can I just press you on one other matter?
Oh, of course.
Which relates to something you said before. You answered my lord saying, well, yes, there's a perfectly good, pragmatic policy behind this, and it works in a very pragmatic way. Now what's said against you, I think, is effectively that if you confine the words in the way you're suggesting, you then got a cohort of people who are subject to not identical but pretty similar restraint on their liberty, certainly not at one end of the normal wing of prisoners, who do not have any of these protections at all, and so they fall in a kind of a limbo land. That is, they're not protected by 45 and 46 and the best policies there. They're not in a normal category. They're suffering very similar circumstances, and all they can rely upon is the application of Article 8.
And the answer is
that may be said to be an unlikely, if you're able to submit, that is an unlikely situation.
Well, my lord, it depends which cohort we're talking about. You can't be talking about the cohort that fall within Rule 45 and are permitted limited association.
The MCBS people.
I made my submissions about those, but the MCBS people, they are permitted to associate. They are not permitted to associate at the same level as those on the wing. But this is specifically designed, which is why I gave you those references at the outset, to be, as it were, the halfway house. And at some point, it's for Parliament, I submit, to draw a line. And what Parliament has done is to draw a line at segregation. It has said you need statutory authority of this kind and all the processes attached to it for segregation. Why has it done that? Well, it's done that because, as we all know from lots of those cases which consider segregation, Shahid, Borgas and all of those cases, it does that because there are well-known and well-established concerns about proper removal from association, in other words, the denial of human contact. Now, of course, one could have a de minimis position where my Lord's question will become much sharper, but I respectfully submit that we are not in that territory here. They are allowed to associate. The governor can't do as he can in the segregation situation of Rule 45 or when they're in the CSC. He can't simply revoke those privileged access. They are allowed to associate. And Mr. Justice Lewis fairly set out, properly and accurately set out, the nature of that regime. But it does involve association, if you will, as a right. And it does involve, because of the nature of the unit, an intention, because this is the very purpose of this unit, to try to progress them.
But I think, is it not common ground that even within the MCBS, the prisoners are effectively locked in their cells for 22 hours out of 24?
I don't know what the evidence shows about that. I don't think it is that.
No,
But we have the facts from Mr. Justice Lewis's judgment. I'll find you the relevant bits, if I may, over the short adjournment which is coming. So there are similarities. I think the principled answer to my Lord's question is we are not in a de minimis situation where this is just a kind of abusive thing to get round segregation by another name. And then there is a line to be drawn. And the line to be drawn is for Parliament, subject always to the protection of Article 8. It is for Parliament to draw that line, and Parliament has drawn the line at segregation. Segregation meaning removal from association back to those cases.
Is that convenient?
It is. Terrible case to be recorded for.